Mr. Moss, how do you respond?
Thank you very much. Please be seated. All right, at this time, the court has two matters set for arraignment. 2015 CR 136, State of Ohio versus ReJeana Moss, and 2015 CR 137, State of Ohio versus David V. Moss. It appears that both defendants are present before the court at this time. In connection with these proceedings, you should understand that you both have the right, or each of you has the right, to be represented by counsel throughout every stage of these proceedings, even if you intend to plead guilty. If you wish to hire a lawyer, you have a right to have a reasonable continuance from today in order to secure counsel. If you cannot afford to hire a lawyer will be appointed by the court to represent you with no cost. There is a $25 court cost assessment that is now required to be made in every case in which counsel is appointed. It's supposed to be paid to the clerk of court's office within 7 days after the appointment. If it's not paid, it can end up being charged as court costs in the case. However, if you do qualify for court-appointed counsel, that $25 would really be the only fee, and the rest of the expenses for the attorney's representation would be handled at public expense. Now, you have a right to have bonds set by the court if these are available offenses, and you should always keep in mind that you need not make any statements at any time, and that any statements that you do make can and will be used against you. I have the record show at this time that the State of Ohio is represented by the Ashtabula County Prosecuting Attorney Nicholas Irochi, and we will also show, I guess, that Attorney Joseph Humpollock is currently seated at the defense table, and also Attorney Virginia Miller. They are here at the request of the court. But before I go any further, I need to make a determination with regard to the financial disclosure affidavits that were submitted on these cases. So I'm going to take case number 2015 CR 136 first. This is the State of Ohio versus ReJeana Moss. This financial disclosure form that I have up here shows that you do not have any source of income whatsoever. Is that correct? And have you ever worked?
Yes, sir.
When is the last time that you had a job?
About 15 years ago. I've just been doing kids since.
All right. Do you have any bank accounts?
Yes.
What type of bank accounts do you have?
We have one that's automatic withdrawal for the house payment.
That's a checking account, is it?
Yes, sir.
Do you know what the balance is in that account?
No, sir.
You have no idea what the balance is?
I think it was like about $1,000, $1,200.
All right. Any other accounts?
I had another one, and I think that balance was $800.
Anything else of that nature?
No, sir.
Do you own any real estate?
The house we live in?
All right. Do you know if there's any equity in that property?
Probably not.
You're paying a mortgage to the bank, are you?
Yes.
Do you know how much you owe on the mortgage?
$65,000.
Do you have any means that you would be able to hire a lawyer at this time to represent you in this case?
Not at this time that I know of.
All right. It appears that you are eligible to have court-appointed counsel. However, Mr. Humpollock, I guess I'm given to understand there may be some conflict with your office to continue the representation of Ms. Moss.
Our office represented David a few years ago, and all the parties involved in this case were parties that were involved in that case. So I'm going to ask the court to appoint. I just found out after I talked with Ms. Moss this morning for an hour and a half after I contacted my office. So I'm going to ask the court to appoint her an attorney who doesn't have the same ethical situation that we have. However, we could perhaps as an amicus friend of the court do the arraignment. That's all I can do.
All right, so that we can proceed with this matter, I would appreciate it then if you would go ahead and at least conduct the arraignment, and then we can determine if we're going to have to secure some other counsel to represent Ms. Moss.
Very well.
Now, Ms. Moss, when did you first receive a copy of the indictment with these charges?
The day that it was dated.
All right, it looks like it was filed with the court February 26th. It also looks like you were arrested on February 26th, is that right?
Yes.
Have you remained in jail since the 26th on this case?
Yes.
Do you understand what you have been accused of in this indictment?
Yes.
All right, Mr. Pollock, are you prepared then to proceed with the arraignment on this case?
As a friend of the court, Your Honor, that's all I can do at this point. We would, I will proceed here. We will waive the reading of the indictment without waiving the right to object. Any defects that may be present therein. At this time, we'll enter a not guilty plea to all charges within the indictment, and we'd like to be heard on the issue of bond if the court will allow, please.
All right. We'll show a plea of not guilty at this time. Go ahead if you have any information that will
Yes,
assist the
sure.
court in deciding
Ms. Moss is 64 years old. She has no prior felony record of anything. She has no prior record at all, period. She has a number of medical problems. I've been led to believe that she may have a doctor's appointment this coming up Friday, which is the 6th. She has a low ORAS score, and she's been an Ashtabula County resident for about 30 years or so. I would submit to the court that I would like to ask for a reasonable bond that be set in this case. We also agreed to a no contact order.
All right. Mr. Arrucci, does the state have any recommendation for bond on this case?
Your Honor, as the court is well aware, under Rule 46C1 of the Ohio Rules of Criminal Procedure, the court is to take into account the nature and circumstances of the crime charged, and under subsection 2, the weight of the evidence against the defendants. These incidents were alleged to have taken place in 2011 through 2013 at the defendants' homes. Charges stem from claims made by 2 female juvenile children and an adult male who is mentally challenged. They allege that the girls and the male were locked in their separate bedrooms at the Moss residence virtually all day, every day. We estimate to be approximately 22 hours per day. The girls shared one bedroom. The adult male had his own bedroom. They further alleged that they were repeatedly beaten with a paddle by Mr. and Mrs. Moss, and that the paddle was used so often and so harshly that it had bloodstains on it. Buckets and a metal container were placed in the bedrooms of the girls and male to use as a bathroom while they were locked in their rooms. The windows of their bedrooms were boarded up, preventing the children from looking outside. One child would carve marks in the headboard of her bed to keep track of the day of the week. The children were provided very little to eat by Mr. and Mrs. Moss during this time. The minor girls further alleged that Mr. Moss committed sexual abuse on each of them. They were apparently homeschooled most of the time following their adoption by Mr. and Mrs. Moss, but were not permitted to socialize outside of the home for the past several years. This incident, or this investigation, stemmed from an incident that took place in late August when the girls were able to pick the lock of their bedroom, sneak away from their parents' home, take their parents' vehicle, and crash the vehicle, which led to an investigation by the Ohio Highway Patrol. They were charged with unauthorized use of a motor vehicle in juvenile court, were placed on probation in juvenile court, at which time they reported to the probation officer what alleged abuse had been taking place, and the probation officer involved the Children's Services Agency at that time. We understand that the bond that the court is supposed to be set is to be reasonable, but in light of the nature and circumstances of the crimes that are alleged, to have occurred. We are asking the court to set a bond of $50,000, cash surety 10% on both of the defendants. Thank you.
All right.
Your Honor, we would also ask for the conditions that the defendants, if released, have no contact whatsoever with the minor children and the adult male, as well as their foster parents, the parents or the people that they are currently residing with.
All right, well, given the serious nature of the charges, aside from the allegations that Mr. Arraigned has recited, it appears to the court that the recommended bond of $50,000 is more than reasonable in this case. So bond will be set in that amount. Obviously, it can be posted by an approved corporate surety, or, as the state has recommended, with a 10% rule to apply. Will you assign the judge for this case, please?
Judge Cezanne.
All right, this case is being assigned to the docket of Judge Mary Ann Cezanne. Now, her courtroom is in the front section of the courthouse, so that the next court proceeding that will take place will be in that area. If you are on bond, it'll be important for you to stay in contact with your lawyer. Your attorney will let you know when to come back for the next court appearance. If you remain in jail in lieu of bond, then of course you'll be taken to the courtroom by the Sheriff's Department. But any future proceedings will be in the court of Judge Mary Ann Cezanne. All right, Mr. Pollock, anything further at this time on behalf of your client?
No, I'm just asking the court to appoint Miss Moss, other counsel.
All right. Mr. Roach, anything further on this case as far as the state's concerned?
No, Your Honor, thank you.
All right, thank you.
Your Honor, are you putting a no contact order on?
Oh, I'm sorry. I'm glad you asked me that, because I think that was also a reasonable request. So as part of the condition of release, there will be no contact with any of the alleged victims in this case or with their current foster parents. All right, next is 2015 CR 137. This is the State of Ohio versus David V. Moss. Mr. Moss, I've also reviewed the financial status affidavit that was supplied in your case. It is showing that you do not currently have any source of income. Is that correct?
I don't know if I have a job.
All right. Apparently you were working when you were arrested?
Yes, Your Honor.
Were you arrested on February 26th?
Yes, Your Honor.
And you have remained in jail since that time on this case?
Yes, Your Honor.
Where were you working?
In a mental, sir.
And what did you make when you were employed there?
Carbide cutting inserts.
All right. Can you tell me how much money you would average, say, on your take-home pay?
About straight 40-hour week was a little over 800.
All right. And
That's every 2 weeks, Your Honor.
every 2 weeks was about 800?
Yes, after taxes and
All right. And other than your wife, did you have other dependents that you were responsible for supporting?
oh, Your Honor. I have child support of $161.
Is there a wage withholding order in place for that? Is that deducted from your paycheck when you are working?
Yes, Your Honor.
And you don't know if that job will be available to you if you get out on bond?
No, I do not.
Do you have any bank accounts?
Just ones we have jointly.
All right. Same with the real estate?
I really don't have anything entitled to in my name.
So the house is in your wife's name?
Yes, Your Honor.
Do you have any other means that you would be able to hire counsel?
Oh, Your Honor.
All right. It appears to the court that you are eligible to have court-appointed counsel. So Virginia Miller will be appointed to represent you on this case. When you were arrested on February 26th, were you given a copy of the indictment at that time?
Yes.
And do you understand what you have been accused of?
Yes.
Ms. Miller, Are you prepared to proceed with the arraignment on this case?
I am, Your Honor, and at this time we would waive a reading of the indictment. We would enter a plea of not guilty to all charges, each of the counts listed in the indictment, and then we would request to be heard on bond.
All right. The plea of not guilty will be entered in the case. Go ahead with any information you have that will assist with bond.
Thank you, Your Honor. Your Honor, my client's a longtime Ashtabula County resident. He has virtually no criminal history. I believe he did disclose 1 or 2 speeding violations. He has a low ORAS score. He also has some medical issues. We would request that the court issue a low bond in this case. Thank you.
All right. Mr. Arraigned, I think before you indicated that the bond recommendation was the same for both defendants. Is that correct?
That's correct, Your Honor.
Well, as I said before, given the serious nature of these charges, a $50,000 bond is more than reasonable in the court's estimation. So the bond will also be set in this case in the amount of $50,000. It may be posted in accordance with the 10% rule or by an approved corporate surety. It will also include the requirement of no contact with any alleged victim in this case or current foster parents for those persons. Now, since these are charged as co-defendants, that means that this case will also remain with the other case on the docket of Judge Cezanne. As I said to your wife, if you're on bond, it'll be important for you to stay in contact with your lawyer so that you will know when to come back for the next scheduled court appearance. If you remain in custody, of course, then the sheriff's department will take you to the courtroom anytime there's a scheduled hearing on the case. Ms. Muller, is there anything further that you have at this time on behalf of Mr. Moss?
I do not, Your Honor. Thank you.
Mr. Arraigned, is there anything further at this time on behalf of the state?
No, Your Honor, thank you.
All right. Thank you very much.
Mr. Moss, there's a reason that you locked them in their rooms. What did they do?
They pled not guilty.
What did they do to end up here today?
Oh, I'm sorry.
That's all right.
Mr. and Mrs. Moss were alleged to have abused their children, their adopted children, those being 2 juvenile girls, 1 adult male who's developmentally delayed. They're alleged to have locked their children in their rooms upwards of 22 hours per day. They also were alleged to have beaten the children using a paddle repeatedly and so harshly that there was blood stains on the paddle. They are alleged to have, Mr. Moss is alleged to have committed sexual abuse on the 2 girls. And so there are a bunch of, and slew of other issues, but that in summary is
What has been the impact on the 2 girls?
They've been seriously harmed psychologically, but the girls are doing especially well, and they're in the process of being adopted by another family.
Can you describe the conditions in the home?
They were deplorable. Well, I'm not going to go into the details. Suffice to say that on September 17th, 5 days after the children were removed, a search warrant was executed at the home, and several items of substantial evidentiary value were found in the home supporting the kids' claims.
Were they deprived of food?
Yes, we believe they were.
What were the physical conditions like? And malnourished?
They were malnourished. They were very thin. If you look at them now versus the way they looked back then, they're almost different children.
Is there any way to quantify how bad it was? I mean, in terms of, were they, 20% less than what they should have been? Okay, all right.